Okay, so I think we can start now at 3:34. Good afternoon, my name is Arturo Ureña, and I am the legal clinic coordinator here at Part of the Solution, and I'm joined by my legal team that is here with me. Um, we are going to stop a couple of times for questions, so if you have any question, you can feel free to add it to the chat box. And if, bueno, voy a decir esto en español, si necesitan alguna traducción, actualmente no vamos a estar dando ninguna traducción porque tenemos otro seminario, otro taller el jueves y voy a poner la información en los comentarios para que se puedan registrar para el taller del jueves. I'm just saying that today we are not providing any translation because we are going to have a workshop on Thursday and we will be providing the information in the chat box as well so that people can register for the Spanish version of the workshop. So let's start it.
I just want to say a quick hello if I can. My name's Beth Maris. We said hello earlier, but everyone's been joining us gradually. I'm going to be doing the training together with Arturo Urena, who's introduced himself already. Thank you all so much for joining us. We're also joined by some of the other members of the POTS legal team who have their cameras on, and we're asking everyone to put any questions that they'd like us to address during this presentation in the chat box. We believe you are going to all be muted for the whole training, so our apologies for that. We're just trying to make sure we have good sound quality and that you can all hear the presentation. And we do have a PowerPoint that we will be planning to share by email after the training is concluded, probably tomorrow. And I just want to thank you all again for joining us, and welcome.
Can you all hear me right and also see the PowerPoint? Great. Okay, let's start. Let's start by mentioning what happens when a tenant hasn't paid the rent and some of the things that, some of the steps rather, that the landlord can take. We usually see that right now landlord can make a call, they can stop by to visit, they can send letters, they can send emails or other reminders. Landlords usually do not have the email or some contact information from the tenant. Sometimes they may ask the super or any other staff to contact them on their behalf as well. We usually recommend clients or tenants not to, or like to seek assistance before they are providing some information to landlords. Right now, landlords are trying to see like what information they can get regarding any issue the tenant may have because of COVID-19, whether the tenants have lost their employment because of a COVID-19 related sickness, or their hours were cut. Another step that landlord may take is a 5 days reminder notice, which is basically a notice after the rent has been due for 5 days, stating exactly that. Sometimes the landlord may require the signature for the tenant and for them to send it back. Another notice may be the 14-day notice of rent demand, and that will be a notice that it will be sent direct to the USPS. Sometimes the landlord may send it through the super or any staff member there. But it is important that once you get those letters, if you don't understand what they mean, you should seek assistance either from a nonprofit or calling one of the hotlines for assistance, which we will be providing later on today. Other notices may require the landlord to be sent to send them prior taking the tenant to court. An example of that is the NYCHA Section 8 pre-court notices. We don't, if you are living at a house or at a friend's stabilized apartment, the landlord may not be required to send those, but it is important to know that NYCHA tenants have an additional protection. If the rent hasn't been paid after those notices, the landlord could start the eviction case by preparing the petition and sending a notice of petition. Again, because of the current pandemic situation, things has changed a little bit, and there have been some laws and regulations that we're going to cover later on that requires some additional steps. It is important to know that prior COVID-19, tenant would get the petition and they will have to answer in court. Right now, they can answer by calling a number, which we are providing, 718-466-3000. And that is the number they can call to start the answering process. It is important to know that if you go in person, you may not be able to answer in person, and they may ask you to call that number. So far, I haven't, at least I haven't had any experience on clients going in person and trying to answer, and I haven't had any experience on client trying to answer or receiving a notice, this notice. When tenant get to court, they will have the chance to either settle the case or they can go to trial and fight the case. Now the question, what is housing court? From the legal perspective, housing court is a place where landlords and tenants can try to get different goals. For landlords, they can seek eviction for residential tenants for non-payment of the rent. Again, if the tenant hasn't paid the rent, the landlord can seek that money through the housing court. They can also seek eviction for holding over after the landlord believes that the tenant doesn't have the right to remain at that house. For the tenant's point of view, the tenants can seek an order to demand the landlord to fix part of the apartment or to correct any code violations or to stop harassment. Tenants can also seek other reliefs such as illegal lockout proceedings, which basically is when a landlord locks the apartment and leave the tenant outside illegally. We also have the 7As, which is when a group of tenants are seeking the court to appoint an administrator to collect the rent and do repairs, basically taking some powers out of the landlord. In the Bronx, which is where we see most of our clients, the housing court is located at 1118 Grand Concourse for some cases, mostly holdovers and non-payment cases. And we also have a court at 851 Grand Concourse, or usually for night shop, public housing tenants, and also for trials.
Can I take let me just jump in for 1 second, Arturo, if
Sure.
I can. So I want to just explain that what we're trying to lay out for you all is how the housing court typically operates. And then we're going to be talking obviously about how it's operating now in these change times. So for example, going back to the last slide, public housing cases are not currently being held. The room in the basement of 851 Grand Concourse has not been used for public housing cases since the middle of March. So everything is different, and we'll do our best to explain as best as we can about those changes as we go. Thank you.
Thank you, Ben. What happened in housing court? Again, prior COVID-19, tenant may ask the court to get an attorney to represent them, and depending on the zip code, they may be entitled to a free attorney to the universal access. And those 5 zip codes in the Bronx are 10457, 10467, 10453, 10462, and 10468. Again, Manhattan, Queens, and Brooklyn, they also have their own zip codes where they can also get those assistance free as well. And the main requirement is that the tenant have to be or live below the 200% of the poverty guidelines or line. In other zip codes, still tenants can ask for an attorney, And some nonprofit organizations, such as ours, are part of the solution, and many others, they also provide assistance to tenants. Tenants can also bring their own attorney. Cases can also be settled, rescheduled, or adjourned. Attorney can ask for a motion, or they can also go to trial. Most of the cases, unfortunately, they settle on a good way. And settlement may have very different terms, but it should be an agreement that it is acceptable and seem reasonable for both sides. Again, it is important to know that the landlord's attorney does not work for the tenant. And for tenants, we always recommend them to seek assistance. Sometimes landlord's attorney may seem nice and they may seem helpful, but at the end of the day, they are working for their landlord and not for tenants. So it is important to always try to get free services, free attorneys through nonprofit organization or through the court that tenants will know that are working for them on their behalf.
And if I can just add, and part of the reason why we very much wanted to do this workshop now is that I think all of us who have been working with tenants over whatever period of time we've been able to do that have gotten used to a certain set of expectations of what's reasonable, what's normal, what's a basic settlement agreement that someone in a certain position that might be a good deal. Everything is different now. And we very much want people to understand some of those changes because it is important not to agree to things that are not necessary and that are not realistic and reasonable under the current situation that we're in. Things, as I said, are very, very different. We're going to go through some of those changes as we go. But what was reasonable in February may not be reasonable here in July. Sorry.
Sure. Is there any questions so far?
We haven't actually. Let's see. Yeah, so we have one question that's come through on the chat. I don't know if everyone has the chat window open, but if you do have a question that comes up, please just write it on the right side. Open the chat window, and we will do our best to answer all your questions. So the one that we did get just now is, if the tenant lives in the appropriate zip code, should they answer the petition first or contact your office, or I assume any attorney's office, before answering?
Thank you for your question. So I would say, first of all, I want to stress that although the tenants in those zip codes that are listed have the right to an attorney, any tenant below 200% of poverty can seek an attorney, the appointment of attorney through the court process, through calling 311, or by contacting those providers directly. It's a little bit hard to answer. So let me just back up for a second. POTS is not a universal access provider, so we are not one of the providers that gets paid by HRA to represent people facing eviction. However, we are in housing court all the time, and we do accept cases for legal services and legal representation when we are able to. I would suggest that people should first try to get legal advice before filing an answer, if at all possible. That said, we all recognize that there may be a very high demand for services, and people may have a difficult time connecting with people before they would have to answer. The court website does say that people can take more time to answer if they need to, even though there's provisions in state law in terms of how quickly to answer. They can take more time. There is information that we're going to share in this presentation about calling the court to answer, calling the Housing Court Resource Center for advice, calling Housing Court Answers, or going on their website. But I would definitely recommend, if you can secure an attorney first, you're better off doing that. Yes. I see another question about, are people receiving petitions now due to COVID? So this has been something that has been evolving very quickly. Between mid-March and June 20th, there was a moratorium by executive order by the governor. So it was a statewide moratorium, and there were court orders implementing those directives such that there were no new cases being filed after March 23rd, I think after March 20th, through at least June 20th. As of this point in time, petitions are hypothetically possible, meaning non-payment cases and holdover cases, we believe, are being accepted for filing in the courts. There was a news article that I saw earlier today that said there were 7 cases filed, I think last week. I think that might have been citywide. I didn't actually follow the link in the article. But after the moratorium, remember, a non-payment case has to have a rent demand first, so it would have to have a 14-day notice, as well as that 5-day reminder notice. For a holdover, many holdovers also have a preliminary notice that would be required before the petition. So yes, hypothetically, and apparently in reality, there are some people receiving petitions now. We expect that it's a small number right now because those predicate notices were required first. Do we have other questions before we continue? Okay. So again, we're going to speak a little bit about the normal quote operations in housing court and how things have changed as best as we can help explain it to everybody. So in a non-payment case by definition means that it's a case brought against someone who is a tenant who has promised to pay rent, who has a contract to pay rent, and that person has allegedly failed to honor their contract and failed to pay rent. In those cases, in the past, there would be a 14-day notice, there would be a petition, the tenant would file an answer, and they would receive a court date. On that court date, the tenant would often sign an agreement in which they stipulated to the amount of rent that they owed and promised to pay it by a certain date. Sorry, I lost my screen for 1 second. Many of those agreements included what was called a final judgment. So a final judgment, which we're going to be speaking of more in the future, is, as I always try to explain it, as a final outcome of the case. It's just as if you went to trial and you lost, and the tenants basically are agreeing that they owe a fixed amount. So there's what's called a money judgment for a certain amount of money, as well as what's called a possessory judgment. And what that means is if the tenant does not follow the agreement or the order, if it's a court order, they can be subject to eviction after receiving a marshal's notice from a city marshal. The only way someone can be evicted lawfully is if they first have a final judgment and a warrant of eviction. And there are many, many tenants in the city who got kind of held in suspension during this time, in which they may have signed an agreement, they may or may not have had a final judgment, and they may or may not have had a warrant issued. And so people are in all different stages of process in terms of cases that were started before the pandemic shut down the courts. If an agreement did not have a final judgment, it would be called what we call a settlement agreement, which would have to be returned to court to enforce it if the payment deadline is missed. So let's say I'm in court today, I promised to pay my rent by the end of July. If I don't pay it, the stipulation says I can be brought back to court, and then the landlord can seek a final judgment. In that situation, during this time, people were not able to be brought back to court if they had those types of agreements. So even though they missed that payment, the case most likely hasn't yet returned to court, although those cases may be returning soon. Even after a judgment, even after a warrant, what would typically happen is the tenant would go back to court to seek more time if they needed it. Let's say they're applying for a rent arrears grant or FEPS or some assistance. They could, if they need more time to secure those funds, they could return to court and make an application for an extension of their payment deadline and a stay or a suspension of any eviction to allow them to take care of those arrears. And most likely they'd have to address ongoing future arrears that came due since that agreement as well. Can we have the next slide? Thank you. The other broad category of eviction cases are what we call holdover cases, and there's many different types. Those cases are not technically about the rent, although rent may also be outstanding in those cases. In those cases, the landlord is basically saying, you, whoever it is I'm suing, whether you're my tenant or you're someone who I don't recognize to be my tenant, you are in the apartment, I don't recognize you, I am giving you notice that you do not have the right to remain in the apartment, and if you fail to leave by a date, I will bring an eviction case against you. When those kinds of cases happen, if the tenant was still there, they were considered to be holding over, they're staying past their authorized deadline, and the holdover case would be brought. The holdover case, again, there's many different kinds. So it could be somebody has a pet in violation of their lease, a washing machine in violation of their lease. It could be fail to sign a lease, fail to do something that you promised under your lease, or it could be nuisance or even illegal activity or something that the landlord said meant that you were violating your agreement related to the apartment. In those cases, and again, in some of those cases, there would be someone there who the landlord just simply didn't recognize and said they had no right to remain. And so the cases were very different. If depending on the type of housing and the type of relationship, the cases went in different directions. If someone's a tenant, they could argue about whether or not they violated the lease. If someone's not a tenant, they might only be arguing about how long they could stay before they would be compelled to leave. Or we also would see succession cases where someone believed they had the right to step into the shoes of the prior authorized tenant and remain as an authorized household member or become a tenant in their own right. So in those cases, the issues, the dynamic that would happen wouldn't be about paying the rent necessarily. It would most likely be about whether the person who's sued is called the respondent, whether the respondent could convince the landlord that they should be allowed to remain and under what circumstances, or if they acknowledge they did not have the right to remain, what their exit strategy would be in terms of how long they would need to find other housing and whether or not they would pay for the cost of the housing during the period that they remained there. And again, just like a non-payment case, most cases reach a settlement, meaning both sides speak to each other, try to see what they can work out. If they can come to a mutually agreeable settlement, if they cannot, then the case would be litigated in court and possibly go to trial until it would be resolved in one person's favor or the other. So this slide basically explains what's been happening for the first 3 months of the court being limited to essential operations. So we have been in a period of more than 3 months of housing court not being open for what we were all used to as normal operations. Evictions ended as of March 16th in the city, and in the state, they ended by executive order starting March 20th. And that was a 3-month eviction moratorium, meaning there could be no evictions anywhere across the state. And in addition, landlords could not file new cases. And cases that existed before the moratorium started were not allowed to be filed. So as of March 23rd, they could not file petitions in cases that hadn't been started before the pandemic. And cases that had been started before the pandemic we like to say they were on pause, just like the governor says. They were kind of on hold. People had court dates. If they were to come to court for their court date after March 16th, they would be told, you can't be seen today, go home, we'll let you know when we're reopened, or we'll let you know when you can come back. You'll get a postcard, or you'll be notified when the case is going on. So it's been a very strange holding pattern for many people for quite some time. The only cases that the court was doing initially are what they defined as emergency or essential proceedings. And those cases did start, and the courts continued to stay open for those cases as of March 17th. At first, they were held for a few days at 1118 Grand Concourse, and then they moved over to a courtroom at 851 Grand Concourse. And at first, they were in person. Then they very quickly tried to operate those cases through remote appearances. And they've most of them have been done through remote appearances since that time. So that would have included post-eviction cases. Those were all considered emergencies. Illegal lockout cases where someone claimed they had been denied access to their apartment illegally without a eviction, or emergency HP cases. So conditions that were really emergency conditions that couldn't wait for the court to resume normal operations were allowed potentially to move forward as emergency HPs. And what we really want to spend most of our time focusing on is what's happening now. So after the executive order expired, things have been gradually, and even during the executive order, things were starting to slowly move. As of now, the court is accepting new petitions to be filed. Our understanding of how that's happening is just like when if a tenant gets served with a non-payment and they go, or holdover, and they go to answer at the courthouse, we believe they're being turned away and they're being asked to call the number that Arturo shared earlier, 466-3000, to make an answer. So it's just as if they had been at the window with the clerk would ask that you've been sued for rent, you know, is this true, or what are your defenses, or they be asked why they didn't pay rent. They'll be asked that over the phone instead of face-to-face at the clerk's window. We don't actually know who's being allowed in the building, if someone who comes to answer is going to be allowed in the building, or if they're going to be diverted and encouraged to file to answer by phone. Similarly, with new eviction cases, we understand that landlords are not allowed to file them in person, that they are allowed to file them by mail. And there's 2 steps to filing a case. Typically, the landlord would prepare the paperwork, they would go to court, they would purchase an index number, they would endorse the index number and the clerk's seal or stamp on the notice of petition, and they would then serve it, have it be served on the tenant or the respondent, and then they would return to file it with proof of service to actually commence the case. We believe that's being done by mail and not in person, but again, we're not sure if some people are being allowed in to file those cases, and we don't know how many are being filed, other than the news article I mentioned earlier that said there were 7 cases last week. So at this point, new cases are being accepted for filing, is our understanding. We've been told that when those cases are accepted for filing, they will be scheduled. We don't know how soon. And even after they're scheduled, we don't know how, we believe what will happen is they would first have a status conference of some kind. We believe that the court proceedings will be remote as much as possible. So if someone has the ability to participate through a phone or computer, they will be able to participate remotely without coming physically to the courthouse. We believe the first court appearance will be for the purpose of hopefully connecting the tenant with counsel if they don't have counsel already. So it may be an adjournment for the tenant to have an opportunity to be referred to HRA and the legal services provider that is on the schedule for the day, and then reschedule to a future date. We don't know how soon that's going to be or what will happen. That is our expectation about what will happen for new cases for the time being. For existing cases, those are the ones that are, I think we're all worried. I mean, we're about everybody, obviously, but those are the ones that could move towards eviction sooner. So the category that we think is going to be most at risk of eviction the soonest would be holdover cases that had warrants that were issued before March 23rd. At this point, there is still an eviction moratorium. The New York City Department of Investigations governs the conduct of city marshals. They still have a directive that no notice of eviction may be served. There are court orders in place that say that eviction proceedings are suspended. Those are still in place, but we don't know if they'll be taken away today, tomorrow. You know, it's really nerve-wracking and difficult to manage people's anxiety when we don't know exactly how long those things are going to remain in place. So all we can say is at this point, they are not permitted to move forward. We think holdovers are going to be the first category that will be permitted to move forward for existing holdovers with warrants. And we will continue to monitor it. And people who are in that category should connect with counsel if at all possible to try to get some guidance about how to protect themselves. For non-payment cases, they're in a whole other category. So there's been a lot of back and forth in terms of what is being done or attempted to be done to protect tenants facing eviction for non-payment. So there is a state law, which we have another slide about a little further in the presentation, that is intended to protect tenants from eviction who have suffered a financial hardship during the COVID-19 pandemic. We're going to go into the details of how that is contemplated to work. However, people should understand that landlords will still be able to sue for non-payment. It would be very important for tenants to have attorneys to make sure they can establish their qualification for a protection from eviction under the new law. And And it's also going to be interesting because it's going to be interpreted by judges, by human beings, in terms of whether individual people will qualify for the protection from eviction. The other cases that will move forward at some point are, aside from holdovers with warrants, any case with court dates is going to be rescheduled at some point. So those cases that were scheduled starting March 17th, where those cases didn't move forward, will be rescheduled at some point. The court has already started holding conferences for 2 attorney cases, meaning cases where there's attorneys on both sides. And they've been doing remote conferences to try to explore whether settlement agreements can be reached or whether the cases can be resolved. And those are happening now. My understanding is that cases where someone does not have counsel, they're not supposed to be conferenced. And so if a conference is requested and there's no attorney, I don't believe it would move forward. And there's still a no default posture, meaning if somebody's contacted and they don't appear, they should not be a negative consequence against them for not appearing. That case should be put to the side. And again, that's the information we have of operations as of now. And again, the housing court is operating remotely as much as possible. So we expect that if people go to the housing court and they say they want to come in to do any of the things that they used to do in the past, such as try to access services, try to see a court file, try to get information, most likely they won't be allowed in and they'll be given phone contacts to reach out to those people to the extent that that information is available. However, emergency cases are still being held. Emergency cases have returned to 1118 Grand Concourse, and they're being held in room 230 on the 2nd floor. And if someone cannot participate remotely, they are supposed to be given the option to participate in person in those cases. There's been not a great number of them, but there have been some.
There's a question, Beth, if I can interject for a moment.
Yep.
So someone sent in, what if, in the situation if someone was evicted pursuant to a possessory judgment, but it was before coronavirus really hit and before like the eviction moratorium, what would they do at this point? Would the case be put back on the calendar, or what do they do?
So nothing, thank you for the question. So nothing would be automatic. Anybody who was evicted lawfully before the pandemic, or unlawfully, I suppose, has the right to petition the court for post-eviction relief. So that looks pretty much the way it did before the pandemic happened. So let's say there's a non-payment case and somebody either didn't stop the marshal's notice in time, or the court declined to stop it because they didn't present enough proof of a good reason to stop it. That person can still seek a post-eviction order to show cause. They would have to present their information about their ability to satisfy whatever their obligation was before the eviction. And they would, and a lot of time has passed at this point. So normally what happens in a post-eviction posture is the person would have to pay the arrears through the date of the eviction, plus the rent that came due after the eviction, plus legal and marshal fees, to the extent that legal and marshal fees were awarded, unless it was an illegal eviction. And so I think in the beginning, there were quite a few post-eviction cases that were filed. Those would be filed by the respondent that was evicted. At this point, I imagine there's relatively few, but hypothetically, there could be someone who would still have the right to seek that relief, but they would have to convince a court that they had, they would want to come with whatever the document, the stipulation or order was before they were evicted in terms of what they could do to satisfy it. And they would want to try to show their ability to satisfy that plus the additional arrears. One thing that reminds me is that emergency cases, all the post-eviction cases that were filed after the court was in emergency operations only, referrals were made through HRA. And so many people were connected to counsel when they did file post-eviction cases after the pandemic had shut down the normal operations. The more time that has passed since an eviction, the harder it is to get someone back in. So now that it's almost 4 months later, I would say chances would not be good, but anybody who thinks they should qualify, or anyone who just wants to find out what their options are, should consult with an attorney. Okay. The next slide is a little bit of information about a federal law that passed. So you've probably all heard about the CARES Act, which resulted in money that went to many people. part of the federal stimulus package. And one of the things the CARES Act provided for was a national eviction moratorium. It started when it was passed on March 27th for 120 days, which we've counted to be through July 25th, for non-payment cases in some buildings or tenancies with a connection to federal housing programs. So that includes public housing, that includes Section 8 tenancies, and it includes some other buildings that have a connection to federal programs. So that, for example, low-income housing tax credit, many tenants are in buildings where the landlords receive or participate in the low-income housing tax credit program. That's one of the programs that's covered by this. So a tenant may not actually have a subsidized rent, and they could still be potentially covered by the CARES Act. So the CARES Act provided a moratorium on non-payment cases for apartments that were covered by the Act. And after the moratorium ended, there would be an additional 30-day notice required before existing cases that were in court for non-payment could move forward. And I'm trying to remember if new cases needed a 30-day notice as well. I can't remember that piece, but it seemed under the way the act was written, there would be basically another 30 days for most people that would extend the moratorium. CSS, Community Service Society, did a training that I attended that had really good materials about how to find out if your apartment is covered by the CARES Act. So all I can say at this point is that you should be consulting with an experienced housing advocate or with an attorney if you want to find out if an apartment is covered by this. Now, again, we don't know how many people are going to be facing eviction before these time periods expire. We don't know how many cases are going to come up, but it would be another thing that we would want people to check to make sure that they are getting the full benefit of the laws to protect them from eviction during this unprecedented time. Next slide. Okay, so I apologize for this slide. I will admit that this was the slide that was the hardest for us to put together because things have been constantly changing, at least that's how it feels in the housing world. So as of yesterday, the governor rescinded an order, and we rewrote this slide. And I just want to explain kind of the overview about what's happened in New York State during this time. So we talked before about the early time, the first 3 months of the moratorium, and that period was pretty easy for us to explain to folks because the governor said there would be no evictions and no foreclosures for 90 days. And it was spelled out very clearly in that first executive order. After that, it's been hard to try to make sure we have the best information and to try to figure out or anticipate where there will be changes and how quickly those changes may take effect. So before the expiration of the first governor's order, there was another governor's order that was passed, which is 202.28, which provided for, he called it a moratorium until August 20th. It wasn't actually a full moratorium. It was partial protection for tenants who were unable to pay rent, who were facing non-payment cases, if they had a financial hardship. But after the governor issued that order, the New York State legislature also acted, and they have passed 2 laws, one of which I believe led the governor to withdraw the order through August 20th. So the state legislature passed a law, the first one that they were passed around the same time, but the one that was signed by the governor first was the Emergency Rent Relief Act. And the Emergency Rent Relief Act takes or sets aside $100 million from in CARES Act funds designated for New York State to provide a temporary voucher program that will be potentially available to help low-income tenants around the state pay a portion of their rent for the months from April through July of this year. So it's a short-term temporary voucher program. The criteria to meet it are fairly strict. You have to have an income, a household income of below 80% of the adjusted median income, which is fairly high. Most of our clients in the Bronx, we found, would probably meet that income threshold, the ones that we work with. However, they have to be below 80% of the adjusted median income as of March 7th, and as of the time they apply for the voucher. They have to have a rent burden of more than 30% of their income, and the voucher program will be administered by HCR. So we all know it's July already. This bill passed in May, was signed in mid-June, and we have no information yet about when someone can actually apply for the program, how, who's going to qualify. there is language in the law about the priorities that should be given. So we do expect it to be available to some people. We don't expect it to cover anywhere close to the total need that people are going to have that would potentially qualify. And all we can say is we hope that the rules are and information about how to apply for it are available soon. And we will do our best to help as many people as we can access that program once we have information about how to access it. So it is something. It's a step towards meeting the tremendous need that people are facing during this time, but we don't think it's going to begin to meet all the need, unfortunately. The other law that passed has potentially, I think, a broader impact. And that law was passed also in late May. It was signed by the governor on June 30th. And it provides that tenants who suffered a financial hardship between March 7th and continuing through the restrictions on public gatherings and the restrictions that are required by the public health pandemic. So it's open-ended at this point. We don't know for how long that period is going to be. That people who suffered a financial hardship during that period may not be evicted for rent that comes due during that period. And the way the law is written, the landlords can still sue for non-payment of rent. They can still obtain what are called money judgments, the money judgment portion of a judgment, but they should not be granted possessory judgments. They should not be granted warrants of eviction if the tenants meet the criteria under the law. This is another reason why it's very, very important for tenants facing eviction during this time to be connected with counsel, because we expect there's going to be a lot of conflict over who qualifies for this and who doesn't. And it's going to be very, very important to have an advocate in the tenant's corner to try to establish their eligibility and to maximize the coverage potentially from this law. So again, it doesn't mean rent is not owed. It doesn't mean that someone could recover a debt. It means that they should not be subject to eviction for the rent that they're not able to pay if they qualify under this law. And it's because of that law that I believe the governor rescinded the partial eviction moratorium until August 20th, because this is potentially of broader consequence. And I think executive orders, I read a little bit about executive orders and what they're supposed to do. If the legislature passes on the exact same topic, that would take precedence over a temporary executive order is my basic understanding of the way administrative law would work. So again, this just happened. We don't know how it's going to be implemented or applied, but it's potentially a really important protection for tenants who are facing eviction, who are unable to pay the rent due to financial hardship during this time. The other thing that has been done, and this is the other one, if you can just go back for a second, thank you. The court system has issued a number of administrative orders. These are available nycourts.gov. There's statewide ones. There are local ones under the Housing Court tab under that webpage. I find them confusing, and it's a lot to digest. And all I can say is, as soon as I start relying on one, I feel like it changes. So again, I think people should try to connect with attorneys to just make sure they have the latest information about operations and limitations to protect clients. And the last thing we have on the slide is just to remind everybody that things are constantly changing. What we have in this PowerPoint may not be accurate tomorrow. We had to change it from yesterday to today. We're doing our best to give you our best guidance from all the sources that are available. But just recognize things may be changing, and it's important to be connected with an experienced advocate or attorney to help guide people through the process. And the number that's on the bottom of this slide is there's a resource center in Housing Court, which are closed now for in-person operations, so people can call there to consult and get information. Housing Court Answers has also been a tremendous resource for folks, and their contact information is on the last slide of our presentation. Thank you.
Okay, before we start taking more questions, let's go through some of the things that tenants can do to protect themselves against eviction. Some tenants may qualify for some benefits. If you have lost income, you may qualify for UIV, unemployment insurance benefit. You may qualify for public assistance, cash assistance, or food stamp, and other benefits. If you are not sure whether you qualify or not, you can feel free to contact us at our email or phone number, which I will be it is provided at the end of this slide, or some other organization also have these services for the community. If you owe the rent, you can always go up, apply for rent emergency assistance from HRA. This is also known as a one-shot deal, some people call it. Home Base and other nonprofit providers also provide assistance in the community. Again, you can always call 311 and they will provide information based on your zip code on which organization you can contact and which program you may qualify for. You can also reach out to your landlord if you have experienced financial hardship. Again, this is not something that landlords usually do. Like, we haven't seen it that often, but again, you can always ask the landlord whether they will reconsider renegotiating or reducing your rent. Personally, I haven't seen it, but again, this is something that tenants can also do. As I mentioned before, calling 311 will be also good resources because they can pinpoint you or guide you to the right organization based on your zip code and where you are living. And also you can contact the Housing Court Answer. That is a nonprofit organization as well that usually provide a lot of resources. That is the website is there, housingcourtanswers.org, or the phone number 212-962-4795. And they have offices in the courts. I'm providing the number. I believe that's the office in the Bronx. You can always go and check on the New York State courts at nycourts.gov. They usually update any court operation changes on eviction and also on their own operations. Check for local media. Again, a lot of things are changing rapidly and every day, like from yesterday, from today to today, and always you can check on the news. The government also has done I guess a pretty good job notifying the state in any changes any changes that have been made. You can always contact us at Potts Legal Clinic. Phone number 718-220-4892, extension 111, or you can email us at legalclinic@pattsbronx.org. Again, there are many organizations in the Bronx that are also assisting clients, and again, most of the time we work together to assist the client in the Bronx and any other borough. Beth, is there anything you want to add?
We wanted to save time for questions. So I guess we just want to acknowledge again that this is a time of tremendous uncertainty and confusion and anxiety. Those of us who've been doing the work for a long time, I think, have been looking to find our bearings and make sure that we know how to properly advise folks. And, we just all have to, I think, use our creative powers and our imagination and just get the best information that we possibly can, and recognize that we should just make sure that we remember that people are experiencing tremendous hardship right now. We have had clients who have passed away. We have had clients who have been sick. I'm sure all of you have as well. Any of you who are advocates and anyone who's living in the world we're all living in right now, there's been a tremendous amount of stress and fear and anxiety. And I think it is unimaginable to many of us that someone having gone through all those things would be potentially faced with loss of their housing at the same time. So we just want to make sure that we are giving people the most up-to-date information that we possibly can and helping people protect themselves and not make any hasty decisions that are not necessary, that they get the best information they possibly can to make sure they stay safe and their families stay safe and healthy. But we'd love to get questions if there's any specific questions people have that they haven't had a chance to ask already. I just want to note that Yvonne Pena from CSS did share the information, a link for how to check if a property is covered by the federal eviction moratorium. So thank you for sharing that.
So I know we spoke, you guys spoke earlier about that the courts have always been open for illegal lockouts, but can you go through the steps to take if you've been locked out of your apartment?
Sure. So if someone has been locked out of their apartment, we always advise them first to go to the police. It is a crime to illegally lock someone out, to evict them, and that can include cutting off services such as water, electricity, and the police would be my first visit or call would be to the police. If that does not resolve the problem, people can file a petition for illegal lockout. They can file that in Bronx Housing Court. They are supposed to be able to file remotely. So there is there's a portal. There's two different ways to file things in housing court. One is in like a portal for emergency cases, so post evictions and some of those cases. And there's a separate filing system called EDDS, which is for non-emergency cases. What I would say is if someone has an attorney, your attorney will know how to be able to figure out how to do that. If you don't have an attorney, I would recommend calling the court or calling Housing Court Answers. You can also go in person to the court if you have to. Again, the court is going to try to divert as many people as they can from court, but if you don't have the technological ability to file an illegal lockout, you can file it in person. You should be permitted in to file that in person. And you'd want to bring whatever proof you have that of what your status was in the apartment, and ID and whatever you can to prove your occupancy there.
Thank you. So we got another question regarding a Section 8 portion. So if a tenant has Section 8 and has received a change in the portion of the rent that they cannot afford to pay, and the office is closed now, how does she do a rent adjustment?
So every office is supposed to have a way to be able to file for those changes, even though the offices are most likely closed for in-person operations. If you want to let us, there's different Section 8 agencies, so it's a little hard to answer the question generally, but for Section 8 vouchers, there's 3 agencies that administer them in New York City. One is New York City Housing Authority, the second is HPD, and the third is HCR. They all have a different administrative process. They should all have an ability to accept applications for a rent adjustment virtually, meaning you could email in the request for those documents. If you want to, I'm not sure we'll be able to answer the specific question online, but if you could email us at legalclinic@pottsbronx.org with your contact information, we'll try to make sure you get connected to the agency that you would need to request the adjustment with. My understanding is that I don't think we had a chance to say this earlier in the training, but one of the things that's made things so challenging is not only the courts discouraging in-person operations, every provider, understandably, to keep their own staff safe as well as keep clients safe, has been discouraging in-person operations. So almost every place that people need to access to get assistance during this emergency time has been operating at least in part remotely. So for example, if somebody needs to apply for an emergency rent arrears grant, or someone needs to apply for cash assistance or SNAP, HRA has closed many of their job centers. They've consolidated staff in fewer locations, and they've been doing as much as they possibly can do remotely. So people can apply through Access HRA to apply for those grants. POTS does have case managers who are working and assisting people in applying and accessing benefits. So again, if you have a specific need and you want us to assist you personally, we'd ask you to email us at legalclinic@pottsbronx.org or call the number 718-220-4892 extension 111, and we'll do our best to connect you. Okay.
Okay. Would you adjust the advice you're giving or include any other resources for undocumented tenants or a residence where at least some of the people living there are undocumented?
So at POTS, we work with many people who are undocumented or who don't have a secure status. And I think it's important to consult with someone who's experienced in terms of what to do. The laws that we went through apply for the protections on housing court and the operations on housing court apply to everyone. There can be some distinctions in terms of government programs, in terms of what people are eligible for and what they feel comfortable applying for. And that's a more nuanced conversation, I think. You know, there's always, since I've been doing this work, there's always an implicit threat or an implicit risk if someone stands up for their rights and they're undocumented, that somehow they'll be putting themselves at risk. It would be illegal for a landlord to do that to someone, and there are city and state agencies that are there to protect people from unlawful discrimination, and we would do our best to connect people to those agencies if it was necessary. But I think it's important to get specific advice about a situation. I mean, one thing I will say is that HRA has been, I think, very, I mean, not that I agree with everything HRA has done, but they are available as potentially as a resource. And I think they do try to meet the needs also of undocumented people to the extent that they can.
Another question, was the eviction moratorium extended through August 5th?
So if we can go back to this slide, or maybe I have it here. So there was an executive order. I think this would have been, yeah, the next slide. It's not actually listed here, but there was an executive order, the one that was issued last night. It's Executive Order 202.48, and it does extend suspensions and modifications of law for another 30 days through August 5th, with the exception that it changed the moratorium in the Executive Order 202.28. I don't know. It's hard for me to answer this question because my best understanding of that is that it means that landlords, there's statutes of limitations for certain things. And if the statutes of limitations have been extended, that means that landlords are not required to bring eviction cases for certain things if the statute of limitations has been extended by the governor's order. I don't believe it means that there's a moratorium when the governor is explicitly saying there's not a moratorium in the same order, and when the state has passed specific language that protects people potentially in non-payment cases. So my reading is not that it's a complete moratorium through August 5th, but that it's a potential extension of the statute of limitation that had been suspended previously. That suspension would be continued by the most recent executive order, which again is 202.48. But it may mean that cases aren't brought because they don't have to be brought. And so if landlords don't have to bring cases, they might defer from bringing those cases, but I'm not sure if they're required to. I see we have a comment from Jay from who's in our workforce department here at POTS. So Jay and some others here at POTS do help people who are seeking work. And there's information about how to contact Jay for an intake and also a list of potential jobs if anybody wants to take a look at that in the chat box. Thank you, Jay, for sharing. I don't know if we have other questions.
Not right now.
Okay.
Yeah, no.
So Arshur, do you have, go ahead.
Sorry. Can we download all of these documents?
So this is a PowerPoint. We're going to share it by email. If anyone has registered, I think everyone who's on here will have given us an email address. So we are planning to send the PowerPoint out afterwards. We're also planning to have a recording of this available potentially to be viewed in the future. If you have any specific questions that you haven't asked us, you can please email us or call if you haven't had a chance to ask those questions. We do typically, we would want to conduct an intake with someone to understand their specific circumstances before giving, to make sure the advice we're giving is going to match their needs and be appropriate for their circumstances. But we very much encourage people to reach out to us in that way if they have questions or needs. And you can also reach out to us if any of you are advocates and not clients and you're seeking to brainstorm about how to handle a situation. We are happy to speak with you and to brainstorm and consult on those cases. I want to give Arturo a chance to share any closing thoughts, and I had a couple closing thoughts of my own after that, if you don't mind. Thanks.
Yeah, it is important to keep in touch with nonprofit organization and also the news, because a lot of things are changing rapidly almost every week. Also, we are going to be having the same workshop in Spanish on Thursday at the same time.
Thank you. And I guess my closing thoughts are just to say again, this has been a very, very, very challenging time. All of us are struggling with how to maintain, protect ourselves, protect our families, protect our clients, and stay current and stay helpful and stay engaged. It's hard to work remote. It takes more time, it takes more energy, it's emotionally exhausting. We all have a lot of fear and anxiety, understandably, because it's a very uncertain world. I hope some of this information is helpful. We're all here as a resource for any of you if you need any extra support, and we're really happy you joined us, and we wish you a lot of luck in negotiating all these changes and in assisting clients moving forward. And if you're seeking help on your own, and we wish you a lot of luck in accessing the services that you may be eligible for. And we just want to thank you for joining us.
Thank you.